Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us this morning. And Roger, navigating USDA disputes is the first thing we want to talk about. Mm-hmm. So let me ask then, what exactly is the National Appeals Division, and why is it so important for the average producer?
Well, it's the end of the process of the administrative appeal process for the USDA. So anytime a farmer's got a program dispute with USDA, you start at the county level, you work your way through the state. Ultimately, you can get to the National Appeals Division in D.C., and we've got a process in administrative law known as exhaustion of administrative remedies that a farmer's going to have to go through that entire process before you can ever get to a court to hear the issue. Well, before the establishment of the National Appeals Division, the NAD, appeals of USDA decisions were handled pretty inconsistently across USDA's various agencies. And so that led to a patchwork of procedures that would end up leaving farmers frustrated. And so Congress enacted the NAD as part of another law in 1994. So it's been around a little over 30 years now.
And so throughout all this process, what kind of decisions are actually appealable? Is it just about loan denials?
No, it covers a wide range of issues, including FSA program payments as well as loan denials, as you indicated. Rural development housing decisions are going to be in there, NRCS wetland determinations, conservation program denials, certain crop insurance decisions, on and on it goes. So just about any type of USDA farm program. Now crop insurance is a little bit different, but some crop insurance disputes are handled by the NAD.
Well, you mentioned crop insurance disputes. They can be particularly complex. So how does that process differ, say, from a standard agency appeal?
Well, crop insurance is a pretty highly specialized process in terms of handling an adverse crop insurance decision. And so your correct path where you go administratively depends entirely upon who made the determination and the nature of the dispute. And so if just to boil it down as quickly as I can here and as easily, disputes with private insurers will often require mediation by contract and binding arbitration under federal rules that would govern those contracts. But if the risk management agency is involved and they're directly involved, then the case moves to the NAD and works through the USDA process. So that's the short answer to your question, and it depends. Are you dealing with a private insurer or are you involving the RMA?
So let's just say on the appeal process, the farmer gets a denial letter in the mail today, if they get the mail on Mondays, which very few do now. What is the very first thing that they need to watch out for if they say want to fight it?
Yeah. Well, I'll tell you what the thing is you don't want to do on that, which I get these calls all the time. You got 30 days as a deadline to file an appeal. So I get one of these, and it's day 29 or it's day 30. And finally, the farmer realizes, oh, I probably should pay attention to this. Don't do that. That 30-day deadline for filing an appeal with the NAD, if you miss that deadline, and you could have gone all the way through the process. So you started with the county people, you've gone through the state, and you've gotten an adverse decision all the way through. Well, you get a 30-day letter, and it tells you got 30 days from the date of this letter to file an appeal with the NAD if you want to. If you miss that deadline, that can result in a permanent loss of the right to contest the decision. Now, there's that 30-day deadline that's all the way through the process. And when you're dealing with the county, when you're dealing with local people, the state, there's some flux in that 30-day deadline. I would encourage people to follow the deadlines, but your local and state people are much more willing to work with you on that and understand if issues come up than the NAD is. Don't miss the 30-day deadline with the NAD. That's the one thing, Greg. I would say that's the very first thing they need to watch out for. Just pay attention to that 30-day deadline.
So let's take it a step further. So say once they file the appeal, what should they expect from the hearing itself? I mean, does the burden of proof lie with USDA to justify their decision, or is it with the farmer?
Yeah, it's with the farmer. You bear the burden. It's like battling the IRS. Most of the issues you got with IRS, you're going to have to prove that the IRS was wrong. There's only a couple situations there where you can flip that and put the burden on the IRS. But here, you got to prove your case, and you got to be prepared. And that's a big issue. And one of the problems, Greg, and I try to emphasize this particularly with my law students, is that encourage your farm clients to retain your help throughout the process from the start. I know farmers don't want to do that. They think they can handle this on their own. Then they get frustrated. They got an adverse decision and they didn't have any legal counsel all the way through. So the record really hasn't been preserved or developed. And they go all the way through, even if they go to the NAT and kick it into the legal system. Well, there are many instances where I can cite to the students here, read this case, read this. What is the judge saying? The judge is saying, you got a good case, but I'm not here to open the record up again. I'm here just to review what the agency did and based on what you presented below, I can't overturn what the agency did to you, even though you've got a compelling case. And what I'm saying here, Greg, is you got to preserve the record, and legal counsel can help you do that. I know it costs money to retain legal counsel, but in the big cases, it's really worth it to do that and be prepared for that hearing. But the burden is on that farmer to prove by preponderance of the evidence that the USDA was wrong in the decision that they made. So success requires mastering the agency record. What is the basis for the agency's determination? That's the full collection of the evidence the agency relied upon, because you're trying to show that was improper somehow. So that, in a nutshell, I think that's the key point for farmers to understand on that issue.
Well, and there's been a lot of talk even now about bypassing administrative agencies and going, say, straight to court. So let me ask then, can a farmer just skip the NAD and head to federal court for a faster resolution?
Yeah, that's come up because of a couple of U.S. Supreme Court cases over the past 2 and 3 years. Now, when you go back to the 1994 Act that created the NAD, that's where, as I mentioned earlier, exhaustion of administrative remedies comes from. That's generally mandatory. But the Supreme Court has a couple of cases out there that can give us an angle here. There are some precedents in limited situations, and they usually only apply to broad structural constitutional challenges, not routine factual disputes. So if you're making some sort of a constitutional challenge to a certain farm program, the agency's powers itself, then you may be able to go straight to court and bypass the administrative process. But still to this day, most of your routine appeals involving USDA, you've got to exhaust administrative remedies and go through the administrative process. I had a question, Greg, that came in from Iowa week before last, from an attorney that was representing a farmer on a Packers and Stockyards Act complaint. And now Packers and Stockyards Act is a little bit different. You got sub-agencies of USDA that deal with Packers and Stockyards Act. And his question was, this administrative process is nightmarish. Are there ways that I can get this? Is there an argument I can make that I can get this into court directly? I don't want to bankrupt my client. And I gave him a long email of some options, some arguments to make, and the case law on this. But we find this on the Packers and Stockyards Act side with GIPSA and APHIS. That's the same issue over there that we have here. So there are a couple of Supreme Court cases that do give us some arguments if we're dealing with kind of constitutional issues and agency authority issues. But on the routine cases, you still have to exhaust those administrative remedies.
Well, I've heard that the way courts look at agency decisions, they've changed. Now, is that true? Is it now easier to challenge an agency's interpretation of a law?
Yeah, that's also another U.S. Supreme Court opinion. That's the opinion in 2024 that is commonly known as Loper-Bright, that reversed the Chevron decision in 1984. And in Chevron, this has to do with the issue of deference. The Supreme Court said, we're going to give federal administrative agencies great deference, and we'll only review to see if their decision was arbitrary and capricious based on the statute at issue. That's no longer the case. The courts make that decision. They're not just deferring to the agency. they're looking at what the agency did kind of anew now. So the USDA is going to have to provide more compelling text-based legal justifications for their decisions, and that can actually strengthen a farmer's argument that it's rooted. Their argument is rooted in the plain language of the law. So that gives a little bit more hope in terms of the review that farmers might win these cases.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, joins us. And Roger, we hear a lot about Indian country in the news, but for a farmer and rancher, what does checkerboard jurisdiction actually mean when they wake up on a Monday morning?
Well, that's a good question. It means that the rules governing your land can change simply by crossing a fence line. So a producer or farmer may own fee land, which is private property, where state law applies, but also operate on adjacent tribal trust land. And if they do that on that land, they're subject to tribal codes or Federal Bureau of Indian Affairs regulations. So managing that effectively requires basically that farmers got to have a jurisdictional map of their operation to ensure that the activities they engage in, I'd say like chemical applications or grazing rotations, comply with the specific authority over that particular tract.
And you mentioned a little bit about a major bottleneck regarding the BLA lease renewals and USDA program and eligibility. So can you explain that particular catch-22?
Yeah, what I'm talking about there in my article is that in order to receive USDA benefits like crop insurance or the livestock forage program, a producer has to prove legal control of the land. Now, if they're on tribal land, that's going to require a Bureau of Indian Affairs, a BIA-approved lease. And so if the paperwork gets stuck in pending status at the BIA, which it can happen, when let's say the July 15 acreage reporting deadline hits, then the FSA cannot link the land to your operation. So you essentially end up in a situation where you're doing the work and taking the risk, but the government treats the land as if it doesn't exist. And so that could potentially cost you thousands of dollars in disaster assistance. That's the bottleneck problem that I'm writing about in the Catch-22.
Well, as many things for agriculture, water is definitely the lifeblood, specifically in the western United States. So how should producers be protecting their historical water usage from being curtailed?
Well, they're going to have to monitor the water adjudication and settlement negotiations closely. Now, state law users operate under, in Kansas, the prior appropriation. Tribes often hold what we call winner's rights. So it's not the prior appropriation doctrine, but winner's rights based on a case on this. Those are federal reserved rights that are frequently senior to state-issued permits, and they can be unquantified, which can create massive uncertainty. So actively, if you get into this situation, I would say farmers have to actively participate in settlements. For example, there was a March settlement in Idaho just last month, and that serves as an example of this. And so it's vital to participate in that to ensure that your historical usage is protected and quantified in exchange for any type of infrastructure funding.
So, Roger, how do trends like 638 contracting and traditional ecological knowledge change the day-to-day management of the land?
Yeah, this is something that is actually in the Farm Bill that is under consideration right now in Congress. We're not hearing anything on this, but I noticed that's in there. What this is a shift toward localized tribal controls. Now, what 638 contracting does is it allows tribes to take over federal programs like forest management or conservation. So what that means to producers is that they may deal with the tribal agencies rather than the federal ones to meet standards. And also the TEK, or the traditional ecological knowledge, they're integrating that into NRCS standards. And so that means best management practices are changing. So practices like prescribed cultural burning or specific intercropping may soon be required for federal cost share eligibility or lease compliance. So there's going to be, if this passes in the Farm Bill, more of that control is going to shift to the tribes.
So if you had to give, say, a piece of advice to a producer feeling overwhelmed by some of these regulations, where should they start?
Well, I think on your lease renewals, if there's a farmer that has their private ground, but then they lease ground that's tribal ground, start those lease renewals a year in advance. Never rely on any automatic BIA extensions on that. And then document everything. Maintain your separate, meticulous records for your BIA leases versus other types of tribal leases to avoid administrative confusion during an audit. And then utilize state resources. You got the Ag Mediation Service here in Kansas. The mediation service can help navigate tribal or BIA disputes before they escalate to what can be pretty expensive litigation. So those are the 3 points on that I think are the big ones.
And Roger, they can people can find more on what we discussed this today on your blog.
On my blog, and my Substack has the more detailed NAD piece, USDA NAD. I have a blog version, then I have a version for attorneys that are advising farmers. That one's on my Substack.
All right, sounds good. Roger, as always, appreciate it. Thanks.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us today on the Ag Issues program here on 580 WIBW.